And well, is 6 minutes after 9, so I think we can start, and then if somebody else will join, we can well, okay. So the the subject of today is to understand better. Let me take my notes, because you know that I have sent this small document of useful text propedeutic to discussion on relations between maritime law and space law, and not only about the space resources and so on. So I can share. So what I think it's interesting for us to interesting concepts to understand for us for the space law is at least these 3 points: use of extraterrestrial resources like the moon, asteroid, Mars, and other celestial bodies in the solar system. Then orbital debris, property, salvage, recovery, and reuse, and rescue and saving life. Okay, so first of all, let's understand if these are the 3 points interesting for us, or we have also some other point. Should we add some item?
Well, rescuing and saving life, there's already a rescue agreement that our rescue convention has been created for space years ago. So that's already covered.
Okay, so it already exists an agreement, you say, right?
Yep. Yep.
And do you know maybe the title of the agreement and who proposed it?
The title of it is the Agreement on the Rescue of Astronauts, the Return of Astronauts, and the Return of Objects Launched into Space. It came into force in 1968.
Is a rescue of astronauts?
The Agreement on the Rescue of Astronauts, the Return of Astronauts, and the Return of Objects Launched into Outer Space.
Agreement.
Its short title is Rescue Agreement of 68.
On. Sorry. Rescue of astronauts.
And it's been widely cited by everyone, including every one of the space powers. So.
Okay. So it was made in which year? 68.
1968.
19. Oh, there is an echo. Maybe someone didn't mute. Okay, I think Amalie, it was your microphone, right?
Now I'm muted.
Okay, great. So it was made in 68 and ratified already by many countries.
Yes, including almost all of the spacefaring nations have ratified it.
All the nations who ratified the Outer Space Treaty also ratified this one. So about
not all the nations in the Outer Space Treaty, but all of the nations that are active in space, pretty much. The United States, China, Russia, European Union, ESA, they've all ratified it over the years.
Okay, okay. Then we will look. We will search for.
Dennis just posted a link to it in the chat box.
Okay. We will check. We will check. Okay. So okay, then we will maybe say understand something about what these this treaty says about rescue, and I believe it may be similar to the sea rescue, could be. Okay, we will see. So, okay, Amalie, just because you entered a little bit later, we were trying to understand if the interesting concepts regarding space law are these ones: use of extraterrestrial resources, orbital debris, property salvage, recovery and reuse, and rescue and saving life. About this last, Thomas say that an agreement already exists, and it was made in 1968 and ratified by many countries. Okay, so this is about the rescue.
Yeah, and the number is 98 states have ratified it, 23 more have signed it, and the three international organizations, ESA,
98, okay.
the Intersputnik Group, and the European Organization for the Exploration of Meteorological Satellites have also accepted it. So it's very widely accepted and agreed to. So there's no issue over there.
Okay. And space agencies, main space agencies, right?
Yeah, I mean, ESA, Russia, Japan, the United States, India, they're all members of it.
Yeah. Good. Well, so, well, in these days, I have tried to understand a little bit more on the several documents that we have linked here. For instance, the 1989 International Convention on Maritime Salvage, that says, okay, Article 10, duty to render assistance. Every master is bound, so far as he can do so without serious danger to his vessel and person thereon, to render assistance to any person in danger of being lost at sea. The states parties shall adopt the measures necessary to enforce the duties set out in paragraph 1, and the owner of the vessels shall incur no liability for a breach of the duty of the master under paragraph 1. So, yeah, okay. However, we will also see what this agreement on rescue of an astronaut say. Maybe we can find it and have a quick view.
Dennis posted a link into the chat box. If you click on that link, you can get the text.
Okay, okay. Let me see. No. To all UN-sponsored treaties. Okay. Space law treaties and principles. Okay, so this is also an important link that we should add to our document. Okay. And okay, this is the rescue agreement. So the Outer Space Treaty, the Rescue Agreement, the Liability Convention, and the Registration Convention, and the Moon Agreement.
Yeah, the liability deals with what happens if your spacecraft hits another spacecraft or it crashes on Earth. It deals with the liability issues of that.
It's about
It was actually implemented back in '78 when a Russian spacecraft with a nuclear energy source crashed in Canada. So there's already law on that.
Okay. So, yeah, let's see this agreement on the rescue. Agreement on the rescue of astronauts, the return of astronauts, and the return of objects launched into outer space. So this is the
Yeah, if you go under languages there, available languages on the lower right, you can get an English copy of it by clicking on English.
yeah.
But there's really no controversy on this agreement. It was adhered to. It was done by a UN resolution, and just about everyone quickly signed it. So there was never an issue with this one.
So okay, so you mean that this is well accepted by everybody. There's no new
98 nations have ratified it. 23
Yes,
have signed it.
yes.
There's
Okay.
only 114 nations that have signed the Outer Space Treaty, so it's the second
Okay.
most accepted treaty. It basically just says that you'll help each other. If some astronauts or cosmonauts or that need help, you'll render assistance.
Okay. So well, okay, it's interesting to read it, but it's not a subject of discussion and controversy, let's say. Okay, good.
The only thing that's come up is where the space tourists apply because are they astronauts or not, but that's just some nitpicking some people have done.
Okay. So okay. Well, I think that the main discussion points are on the the part 11 of the UNCLOS, Convention on the Law of the Sea, which set up the International Seabed Authority. And there is a paragraph of this part 11, which appears to outlaw minor property in contravention of Article 17 of the Universal Declaration of Human Rights. And yeah, it says that the resources in the area are common heritage of mankind, and no state shall claim or exercise sovereignty or sovereign rights over any part of the area or its resources, nor shall any state or natural or juridical person appropriate any part thereof. No such claim or exercise of sovereignty or sovereign rights, nor such appropriation shall be recognized. All rights in the resources of the area are vested in mankind as a whole, and whose behalf the authority shall act. These resources are not subject to alienation. The mineral recovered from the area, however, may only be alienated in accordance with this part and the rules, regulations, and procedures of the authority. So basically, it says that nobody can touch that, but if you get an agreement with the authority, then we can talk about that.
Right. And what happened is in 1994, there was a second agreement called the Mining Convention, which implemented this part of the treaty and set up the Seabed Authority. So there's another treaty you want to look at called the 1994 Mining Convention.
We should look for the 1994
Mining Convention.
the
The
mining
Mining Convention of 1994.
Okay, let me add this.
Let me see if I can find a link to it and put it in the chat. Hang on.
1994. And this convention says something different from the
It modified some parts of number 11 and then set up the International Seabed Authority to implement it and give permission.
okay, so setting the authority, in the international, what it was called, international something,
Seabed Authority.
Seabed.
seabed authority, yeah. Seabed authority. Well, we had some notes about yeah, it was noted that the part 11 of the UNCLOS, UNCLOS, and Article 11 of the Moon Agreement were very similar. That both declare that the resources are the common heritage of mankind, and also it was noted that the word regime appears in both the documents, the UN clause and the Moon Agreement, and also the word authority is mentioned several times, while it was also reported that some other document, in particular the draft building blocks for the development of an international framework on space resources activities made by the Hague Space Resources Governance Working Group, seems to be more positive and open. It doesn't mention the term authority or regime, and in opposition, it mentioned 28 times the word framework, cooperative framework, as well as
That's because I posted the link for the mining convention, but that's because it's been a real mess the way they've done it. Let me give you some background. Back in the 1960s, there was a couple companies that were looking to mine the seabed, and they tried to get some property rights there. And that triggered off the whole Law of the Sea Convention that started in 1966, and they came to the agreement finally in 1982 on what to do with the seabed, because they brought in all kind of other issues like fishing and that. Then in 1994, they made an agreement to implement Article Part 11 of the Law of the Sea, and that was the mining convention, and I just posted a link to that. Then about 10 years later, they finally set up the Seabed Authority in Jamaica, and its headquarters in Jamaica, and they're just now coming up with the rules to determine how to set up a claim on the sea floor. So this is a process that started in 1966, and of course, the people who wanted to mine the ocean floor there are long dead. Most of them are long gone, and they still haven't come up really with a licensing regime for how to do it, which gives you some idea how long it took to, get to where we are now, just in the ocean, where the technology's been there for 50 years to mine these nuggets, but the lawyers haven't agreed how to do it.
Well, however, what we were trying to do today in this meeting, and I'm very concerned because Wes is not here, because he's going to develop our paper for the Luxembourg Space Resources Week workshop. And also, this discussion of today should better inform us for our space law chapter in our position paper. Because yeah, I already have put what I think it could be our understanding of this problem of the space law. That is basically what we consider. Yeah, I think there are some differences that should be made before talking about possible use of maritime law to build the space law. Of course, the Earth oceans are very much different from the outer space in terms of life. In the ocean, our ocean is full of life. Of course, there are fish and vegetables and a lot of living things inside our sea. Therefore, I believe it is reasonable that a document like an agreement like the let me check the convention, no,
Mining Convention of 1994.
yeah, the BBNJ, BBNJ. I don't understand why is not mentioned here, because I thought it was, but I don't see it. Okay. However, yeah, I think we know what I'm talking about. No, the BBNJ is an agreement that take care of protect the marine environment from any kind of activity like a minerary or industrial or anything, and this document, in my opinion, could not be taken and applied for outer space, because basically in the majority of the bodies, celestial bodies in our solar system, apart maybe some moons of Jupiter that have water, so they could have maybe some form of life in, but the moon is completely sterile, and so probably is Mars. So I don't believe we have to be very much concerned about possible forms of life in the range, let me say, of the bodies that could be affordable for us to reach in the next decades. But the BBNJ was, however, mentioned, I think, by Amalie the first time, because it is interesting, the methodology that it proposes, the methodology to establish clearinghouses as a place for discussion, for advancing proposals, and for international agreements and all this kind of things. So in our position paper now, I just sent today my last review, trying to get it smaller. It's now 36 pages and not 44 as it was. However, in this, I mentioned the BBNJ as interesting only for the methodology point of view. So for the concept of clearing houses, and for the okay, now I will tell you what I believe to understand from several discussions that I had with Alfred and other discussions that we had in this committee. Our orientation seems to be more keen toward international framework agreements that allow to proceed in incremental way, taking profit of the best practices while they are developing. So this could be a methodology that is not completely is not overruled in terms of making very coercive treaties that try to rule everything before going there, and in the same time is not completely, let me say, free. Everything left to the jurisprudence that will come up from the litigations, because yeah, these are the, let me say, the two extreme positions. No, on one side we have the supporters of the treaties. We have to make a treaty complete, taking care of all the possibilities, all the conditions that could happen, etc., etc. And on the other side, we have the supporters of let's go there, let's see what happens. And then somebody will have litigation, somebody somehow we will have some infringements of the Outer Space Treaty or other treaties, and the court will work, and the lawyers will work, and they will make jurisdiction. So these are, let me say, two extreme positions. What we are saying, taking, let me say, observing some agreements, the framework agreements that are going on, like the Artemis Accords, initiated by NASA, and to which already 33 countries have subscribed on one side, and on the other side we have the China International Lunar ILRS, International Lunar Research Science
research station.
Sorry?
Research station.
Yes, exactly. That collects, I think, about 14 or 15 countries so far. We are looking at these experiences as interesting experiences that are trying to to go ahead, to go over the limitations that are still present in the Outer Space Treaty, or to propose interpretations of the Outer Space Treaty that are not so coercive, let's say, binding, and on the basis of this experience, to understand which are the best practices, to try to avoid litigations, and to well, let me say, to accompany the space venture, trying to make it in a well-sorted way, in a not too disruptive way, in a collaborative way, and inclusive, and so on. By the way,
Adriano,
yes?
but I think one should say that the Outer Space Treaty is still valid,
Yes.
because it is international law,
Yes.
and all national space laws have to link to this international law. And I think the Outer Space Treaty is the Magna Carta of space law.
Yes, yes, that is true. By the way, for what I understand, but always consider that I'm not a lawyer, therefore I'm just trying to to study and to understand what it exists. But yeah, sometime my let me say my ignorant approach could be useful because it allows to explain things, no? Because some more experienced people can give us better explanations.
But I think our position as an international organization should be a bit neutral. Also, we should not we should not accept only one side of the interests.
Of course not. But okay.
The Western,
So
the Western view.
Let me say our position from our humanist point of view is in favor of the humankind and our civilization. So for our analysis says that we have to start moving, to start expanding before 2030, and to encourage and support all the initiatives that go in that direction. Therefore, good is the Artemis program, good is the China program, good are any program that try to go there and start to work. So we it doesn't mean that we will support anyone living with a Conestoga car and going to take property of some areas on the moon. Of course, I'm just kidding, because nobody will do something like that.
Okay, this is
However,
Wild West.
Yeah, exactly.
Methods.
Yeah, and in the sense, so I think that this position that we are that we have inserted in our position document, position paper about the space law, that we are looking with favor to the international framework agreements, because they allow to go ahead, to go there and to start working, trying to respect the existing law, and when it is needed to modify it, because some articles of the Outer Space Treaty maybe need to be modified. But one of the things that I understood, or maybe I understood, is that the existing treaties make a difference between the resources and the territory. So while they say that the territory cannot be claimed by any state or any private or any kind of entity, nobody can claim an area on the moon and say, this is mine. Okay. But in the same time, the treaties are allowing the operators to go there and take resources and work and start working with the resources. So
the exploration, exploration is allowed.
Exploration, but also, okay, if we check, for instance,
the way to understand that is simple.
This
you're in the middle of the ocean. You don't own the ocean, but if you catch a tuna and you bring it on your ship, you do own that tuna.
Okay. But no, I was thinking not about the fish. I was thinking
right.
Minerals.
And it's the same principle. You pick up a rock, you own the rock, but you don't own the land that the rock was picked up from.
Yeah, so what I understood is nobody can be proper yeah, proprietary of
You're confusing real property and shadow property. Does property like a rock you pick up? Real property is land, and no one can claim the land on the moon. No one can claim the land in Antarctica. But if you go to Antarctica and you pick up a meteorite, then that meteorite belongs to the government, NASA, because that's who picked it up. Same thing, the lunar samples belong to the US government because it was US astronauts that picked them up and returned them here. And the case law that has taken place with those lunar samples has been based on the theft of government property law. Because when they were picked up by the astronaut, they became government property, the rock, but not the place where they landed. So there's a separation there between the land and the rocks you pick up.
Yes, but let's think. Let's make a case, for instance.
Okay.
In 10 years after the Artemis mission was successful and a first base on the moon was placed there and so on, let's say Jeff Bezos will start to process, regulate and extracting helium-3.
Yeah.
So Jeff Bezos will go to the authority and say, I am interested to do that.
But there is no authority.
No, by now, no. But if they will make an authority similar to the seabed mining, no, international seabed.
If they make one, but I don't think there's going to be one. There's no, some countries run that, but given the problems with the seabed authority, it's unlikely that's going to move forward.
It's unlikely. Oh, so you mean that there are many.
The authority that's under the Moon Agreement is unlikely to be created. Only the Moon Agreement countries are bound to that.
Yeah, I fully agree with Thomas. A supranational authority that's already in place in the law of the seas is never going to happen for outer space.
Okay.
The possibility is there in the Moon Agreement under Article 11. They talk about states making one of those things. But all of my experience since I've gotten involved in space law, including what's going on right now at the United Nations with their new Space Resources Working Group, they're probably going to put in place, I'll back up a step. The Outer Space Treaty just says you can't appropriate anything. The Moon Treaty says you can't appropriate resources in place. And this is what Thomas is talking about. Once you remove a resource from in place, once you pick up that rock or even a handful of regolith, that becomes a resource that the person owns, whoever removed it, whatever entity that is, the individual, the company, or whatever. So they're going in that direction. They're going to probably confirm that people have what Thomas called chattel property. Some people call it personal property. That you will have the property right to that stuff that you remove from in place. But when it comes to creating an international authority that says, okay, you can do this, you can do that, that's just not going to happen for the same reasons the Moon Treaty wasn't. They're very afraid of the phrase.
The Moon Treaty was not recognized by many, including USA.
Right. And the reason is because of the phrase "common heritage of mankind."
Oh, okay.
Which was used in the
go
law
back.
of the seas.
Let's go back to my question.
I was trying to get to it.
Jeff Bezos. If Jeff Bezos want to do that, who should talk with?
Well, he's a U.S. government. He's a U.S. citizen. And so under Article 6 of the Outer Space Treaty, he'll have to get permission from the U.S. government. Whereas the Department of Commerce or the FAA is up in the air at the moment. But it would be from the U.S. government because on Article 6 of the Outer Space Treaty, the U.S. government is responsible for his actions.
Okay.
But the U.S. government has to respect the Outer Space Treaty. This is the point, and I think the the conflict is that when a big company is on the moon and is mining and in building something, and other countries with not so big companies also want to mine their resources, then you have the conflict, I think. And the Outer Space Treaty says, in my opinion, that these resources are for all mankind and not only for a big company. Also,
Yeah.
if it is a US company.
Yeah.
Well, you know, that whole thing was actually solved almost 50 years ago for the Clark orbit, the equatorial geosynchronous orbit, because the whole issue came up who could put satellites there. And the way that was solved is the International Telecommunications Union, which is part of the UN, decided that you could put satellites in the slots that are no more than 1 degree of arc, and they wouldn't interfere with each other. And they set up these slots, and some countries got slots and some companies got slots, and these slots now are traded between companies. You know, you can sell a slot. And that's how they organize the geosynchronous orbit, where everyone could, you know, anyone that can get a slot can put a satellite there.
Yeah, and also, yeah, and then now listening to you, we also have to notice that Elon Musk is doing that with the Starlink.
Well, that's in low Earth orbit, and that's another issue.
Network.
But yeah, he has
That's
license
a
from
low
the
orbit.
FCC.
Okay. However, is using if we think about the orbit as a resource, let's say,
Yeah.
so is Elon Musk is using the a space resource, and he didn't ask anybody permission to do
He
that.
did ask the U.S. government, and the U.S. government approved it.
Okay.
Yeah, Musk was a
And the frequencies the U.S. government approved were approved by the International Telecommunications Union, which is the UN agency that assigns radio frequencies.
Yeah.
Yes.
Adriano, can I say
And then
something?
he broadcasts, when he broadcasts to a country like to Brazil, he needs to get permission from that country to broadcast to that country. Because even though Starlink satellites are available anywhere in the world, if you're, say, in Brazil, you can't connect them unless Brazil made the agreement with Starlink, which they did. And then he turns the satellites on when they go over Brazil.
Yeah.
Okay.
Okay. I'm sorry,
Adriano?
Jerry want to say something since of time.
First
Please.
of all, just coming back to what Dennis said earlier about resources in place and resources removed from a location. I'm a bit confused about this because if you go to the moon and you take rocks and so forth, then and apparently you or your government can own them, but they have been
Yes.
taken from an original location, and you're not allowed to own material from that location. So how does
Okay, what? Maybe this will might make it better. This is how this one lawyer who helped sell the Russian samples explained it. Imagine that
Oh, yeah.
the celestial body is an object in its natural location. So a meteoroid in orbit is a celestial body. It's in its natural location. If that meteoroid hits the Earth, it becomes a meteor and it lands on a piece of the Earth.
Yeah.
Whoever owns that piece of the Earth now owns the meteorite. If it's a private individual, the meteorite belongs to the private individual. If
Okay,
it's a
because
government, it belongs to the government. Now, if that same
It-
meteorite is
statement
collected
does
by a
say-
spacecraft, it
Yeah.
now becomes part of the spacecraft, and whoever owns the spacecraft owns it. And the same thing, if you pick up a rock from the moon, that rock is no longer in its natural position, and so it's no longer a celestial body, and so it belongs to whoever picked it up and took it out of its natural position.
So effectively, we're saying that anybody can go to the moon, scoop up as much material as they want, and it belongs to them.
Basically, yes. It's just like in Antarctica. If you go to the Antarctica and you pick
Yeah.
up a meteorite there, that meteorite belongs to you because it's no longer
Well,
its natural place in
I mean,
Antarctica.
you could challenge that by saying it wasn't originally part of Antarctica, but let's leave
Yeah, but
let's leave that aside.
Yeah.
The basis for our asking this is, of course, that if the material to construct an island one habitat is mostly going to come from the moon, who will own the material? And if the answer is you're allowed to extract material from the moon and it becomes yours, then that answers various other questions, which is
yes,
you produce the habitat, you extract minerals from the soil, aluminium, silicon, etc. You manufacture the units, panels, girders, windows, etc., and you assemble the unit. Because you own the original material, you own the habitat, and therefore it's okay for you to build houses, offices, etc., and sell those buildings to other concerns. And that makes it all very simple and very clear.
yeah, and something to recognize. Every object, there's something called a registration convention. The registration convention requires you to register any object in space. For instance, the Apollo 11 descent module has a registration number at the UN registration
Sure.
implements the registration commission. Now let me go on. So that habitat would belong to the corporation, because you'll probably need a corporation to build it, or even if it's a government, they'll set up a corporation to operate it as an agency. But whatever nation that corporation is registered in as a corporation, because corporations are created by nations, would own the habitat. And the laws governing it would be the laws governing that nation. That's under Article 6.
And presumably, they would be deemed to operate under the regulations of the government to which their organization belongs.
Yes, and that government is then responsible to the rest of the world for their actions.
Yes, but
Okay.
let me say one thing. The Artemis Accord is, let me say, a degree more advanced, because the 33 nations that subscribe at the Artemis Accords, we work together. So it will be not only one state responsible, but maybe it will be a group of states.
Also, who
What
owns
the Artemis Accords do?
who owns the ISS? I think the ISS is also a very good model, because the ISS is a product of a lot of states, not only of one state. And I think this form of collaboration we need for outer space, because I think we have instead of this collaboration, Wild West scenario.
Well, the ISS, that's an easy question to
yes,
answer.
from this
The
point of
modules
view,
of the ISS are owned by the countries that place the modules. There's one owned by Japan. There's an ESA module that's owned by ESA. There's the US and Russian. And then those nations have what are called bilateral agreements governing how those modules interact on the ISS and what the rules are governing astronauts on them. They're called the ISS conventions, and there's a series of them, of bilateral agreements that govern the ISS.
Yes.
yes, it is. Yeah, it is interesting from the point of view of collaboration, but let's not forget that the ISS is not dealing with resources, is not dealing with materials, while on the moon they will be
But
dealing
you are
with
creating intellectual property resources there from the research.
Yes,
And
yes,
that's also governed in the agreement.
of
For
course.
instance, if you come up with an invention in the Japanese module, it's covered by Japanese patent law. If it's in the US module, it's US patent law. That's in the agreements.
Yeah.
Yes, because the material is then from the state, from the nation, Japan,
Yes.
or but as Adriano said, the material of the moon is not the proper the proprietation. No, sorry, I don't know the
Property.
yes, no, of any state.
The problem with this is that you're approaching it from the viewpoint of Western culture, which is very much based on land law that comes down from the king. You know, you had the king would grant patents to the land and give it to people. And, you know, in the United States, the Native Americans didn't have ownership of land. They were, you know, hunter-gatherers. So they had it where anyone could go on the land. But if you use the resource from the land, like you chop the tree down or you picked up a rock to make an arrowhead, it belonged to you. And this is very much a good analogy for what the conditions are in space.
But India, perhaps, also, for example, India has signed the Moon Treaty.
They never ratified it. They signed it, but never ratified it.
Yes, but
And
they signed it.
So
but they
under the
signed
UN
it.
Convention of Treaties, they're not governed by it.
Yes,
You
but
see, under a treaty, there's two things you do with a treaty. You have your representative sign it, but then in order for it to become law, it has to be ratified.
yes, I know, but they signed it. Okay,
But they never ratified it, so they're not.
Yes, I
governed
know,
by it.
I know, because the other states also had no ratified this, no, this Moon Treaty.
There's only
Only, I
17
think
yeah.
only 18 or 17. Okay.
Well, there was 18 states, but Saudi Arabia is
18.
withdrawing from it, so there's now 17.
Okay.
Let's have a look back to this document that I think it's interesting. The draft building blocks for the development of an international framework on space resources by the AG Space Resources Governance Working Group. This is a working group of COPOS, I think. Yeah. So definition of key terms: space reserves and extractable and or recoverable abiotic reserves in situ in outer space.
And that term comes actually from the U.S. 1915 Space Resources Act, where it allowed private ownership of space resources that are abiotic, that is, they're not organic, except for water.
Yeah, not organic. Yeah, abiotic.
If you find an organism on the moon, you can't own it. You can't own a life form, but you can own a rock. You can own the water.
Yeah. Then utilization of space resources, the recovery of space resources, and the extraction of raw mineral or volatile materials therefrom. Then space resource activity, an activity conducted in outer space for the purpose of searching for space resources, the recovery of those resources, and the extraction of raw mineral or volatile materials therefrom, including the construction and operation of associated extraction, recovery, processing, and transportation systems. So while we are reading, I imagine also all the machines that will be used on the moon to do all these kind of things, and also constructions. So we will be in a situation where nobody can own the ground, but we can build something on the ground.
Yep.
Of course, because yeah. Then space object, an object launched into outer space from Earth, including component parts thereof, as well as its launch vehicle and part thereof. And space-made product, a product made in outer space, wholly or partially from space resources. Operator, a governmental, international, or non-governmental entity conducting space resources activities. Then those guys wrote some principles that are also interesting. The international framework should be consistent with international law. The international framework, so when they say international law, I think they mean the terrestrial law. Yes, because Yeah.
And the case law has already emerged on space resources. For instance, the
And-
sale of the Russian rocks through the auction place in England, the cases that have been held in the US on stolen property from the moon. For instance, there was
Yeah.
the lunar sample gave Guatemala. Someone stole it there and tried to sell it in the US, and the US seized it and returned it to Guatemala because it was property of Guatemala.
No,
there's
no, I
already
think
case law on this.
sorry, I think the international law is a outer space treaty.
The outer space treaty, yes, and then also the case law that's been emerging from there. That's been accepted by our countries, and it's
yeah,
also the other laws, because like there's the registration treaty, there's the liability convention, there's the rescue agreement.
in the sense that the outer space treaty is part of the international law.
It is.
Yeah. The international framework should be designed to adhere to the principle of adaptive governance and incrementally regulating space resource activities at the appropriate time. Promote compatibility and predictability of domestic framework of states and internal frameworks of international organizations. Contribute to sustainable development. Prevent disputes arising out of space resource activities. Promote and secure the orderly and safe utilization of space resources. Promote the sustainable, rational, efficient, and economic use of space resources. Promote the use of sustainable technology. Provide legal certainty and predictability for operators. This is important because if we think about investors, entrepreneurs that will be interested to make industrial activities on the moon in the next years, they should have some kind of legal certainty and predictability of what will happen if I do that, and if I do that, it will happen. So I have to agree to make that. I have to have a permission to do that. So they should have
That's why the US passed the Space Resources Act in 2015, and Luxembourg passed a similar law a few years later. So companies that are registered in those countries are governed by those laws, and the government will protect them.
Oh, let me add something here. Example, US space. What did you call Space Resources
Space Resource Act of 2015.
Act?
And
2015.
then let me get the exact name of the Luxembourg law for you, just a minute.
Okay. Good.
And the Luxembourg law is actually key. Let's see. Because Luxembourg is where a lot of communication satellites are registered, because they're a lot of telecommunication satellites.
Yeah, then we will deepen. We will make searches. Take into particular account the needs of developing countries, and this is resonant with what Marie-Luise was saying before, that other countries may have interest, and even if they don't have big companies working and so on. Yeah, so from on one side, of course, the investment of the main investors may be guaranteed in some way, that they invest and they should have the return of their investments, of course. And in the same time, we have to be to provide that everyone else will not be excluded, that they can in some way to participate into this venture, and to have some good return too. Okay, so
Yeah, the Luxembourg space law was passed in 2017.
Okay. Take into particular account the needs of science, of course. Take into particular account the contribution of pioneers operators. And yeah, this is a balance with respect to the others. The pioneer operators, of course, must have their return for what they do, and in the same time, the whole thing should be inclusive. Yeah, this is, I think, a well-balanced provision. The international framework should provide that space resources shall be used exclusively for peaceful purposes.
Now,
And-
that's an interesting one. No, wait a minute, that's an interesting one. Suppose you mine geranium on the moon and it goes into a computer chip that's put into a smart weapon.
Yeah. 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 But yeah,
So how do you make sure that what's mined on the moon, say in rare earths, doesn't go into the use of computer chips for weapons?
yes, of course. Yes, this is also, I think, somehow related to what we are saying in our position paper about colonialism.
Yeah.
That
Or you have the case with Starlink where SpaceX provided it to Ukraine for use for hospitals and that, and then the military started using it.
Yes, that's true. That's true. And however, there is an article in the Outer Space Treaty saying that it is forbidden to bring weapons in space.
Weapons of mass destruction. There's a difference between weapons and weapons of mass destruction.
Okay.
Weapons of mass destructions are atomic, biological, or chemical warfare weapons.
Yeah.
But the Russians had a 20mm cannon on one of their space stations. And then their cosmonauts routinely carry firearms with them in case they land someplace remote and they have to protect themselves from wolves or something.
Okay, we have Amalie. I think she wants to say something. Amalie.
Yeah. So there's a very interesting concept here that the ISS, the space station, the jurisdiction is defined, but it doesn't involve resources because they're not being extracted from planetary body like the moon, right? So on the moon it's different. There's the basis, then the resources are extracted. They're applying that ISS regulation to the lunar settlement. It's not taking into account the fact that the resources on the moon may be very limited. Water's only in one particular place or a certain element in one place. So here in point 8 that you've got up on the screen, I'm not sure what that is actually, but anyway, it says D, prevent disputes arising out of space resource activities. The international framework, that was D. And then there's another note down there about developing countries. They're not going to have access to limited space resources because these will be the needs of developed countries. Those resources will be extracted by large governments and companies that are able to do this. So I think those are kind of stumbling blocks on the way here that we could maybe address in the position paper, the kind of dynamic between those aspects. I think it's very important that we remember that the resources are limited, who the actors are that are extracting them, and that the ISS framework is not necessarily compatible. Does that make any sense?
Yeah, of course. Yeah, the big difference between a space station and a station built on the moon and the activities you can make in both.
But at the same time, there's nothing preventing a developing country from creating a company to go mine to the moon. I mean, it's not like 50 years ago where the technology wasn't widespread. I mean, anyone can pay SpaceX or Blue Origin to send something to the moon.
Yeah, yeah,
So,
that's true.
so you have commercial transport to the moon, and the mining technology, I mean, you can buy that pretty much off the market. I mean, robotic technology, countries will build robots for you. They'll build mining equipment. It's no different than if you're starting a mine, say in Angola, you can buy the mining equipment you need. You can transport it there. I mean, so, you know, in particular needs of developing countries, you know, that's almost an out there because they have access to capital if they choose to. And they could choose to use that capital to do the mining if they wish. You see, where that came an issue in the law of the sea tree was the fact that only a few countries produce, say, like cobalt. And if companies started mining a lot of cobalt, the demand and price of cobalt would fall. And that's where the developing countries raised the question in the RCA tree, and basically that's why they structured our part 11 so it would prevent mining of the ocean floor, so they wouldn't have to compete with it.
Well, I'm just thinking about the position paper for the resources
Right.
week. Yeah.
I want to say that there are also a national space law contracts in other states, in Finland, in Denmark, and I think Norway, and so on. And I think we have to take into account also this other national space laws.
So, Marie-Luise, sorry, you were talking about Denmark and their activities in Greenland, in other countries, in other territories. You were talking about that, or
No,
sorry, so I don't.
No, I'm speaking about national space law.
Yeah.
And not only the USA and Luxembourg have national space laws, but also other countries like Finland, Denmark, and so on. And I think we have to take into account also these other national space laws.
Okay. Yeah.
You know.
Yes.
Because you're only you have only in here an age the US Space Resource Act from 2015 and Luxembourg 2017, but there are also other national space laws.
Okay. So we have to look for that. If you
Yes.
have any references, maybe.
Yes.
I think Alberto wanted to say something. Then we have Jerry.
Yes. So I wanted to attract attention to what Amalie said, especially some resources in space are, in fact, resources that we must consider now in the nearest future are limited. For instance, consider this. On the moon, the quantity of water is very limited for sure. And everybody wants to use the water ice that is near the poles. With the current, with the Outer Space Treaty and the way things are managed, that water belongs to all humanity. And then if someone picks part of that ice, then it becomes of the one that takes it. But since the quantity is limited, potential conflicts are there, because if someone starts using massively that ice, practically the others will be prevented from using any ice on the moon, because if you take all the ice that is in one, if someone else wants to use the same ice, it will be impossible. So conflicts may arise on these kinds of issues. This is this should be treated somehow, because of course, if you just want a regolith, you go to the moon and take a regolith wherever you want. But if you want, for instance, surface ice that is on the moon, it's very limited. The first who arrives there takes it, and then that's all. This will not ensure the possibility of access of all the other nations, for instance.
Yeah. Good point, Alberto. But what should we say about that? Okay, it is a problem. Of course, it is an issue that should be somehow.
But when you are talking about authorities, things, who should assign the ice that is on the moon? Currently, no one.
Yeah.
That's the
Until it's
problem. There
there,
is no
it's,
sovereignty on the
belongs to
moon, so
everybody.
there's no one to sign it. Yeah.
Okay, Jerry.
Okay. First of all, I just want to come back on something that was mentioned earlier. That one of the things that wants to be done is to prevent disputes about something or other. There is no way that you can produce any authority to prevent disputes. There'll always be some people who come up and say, I don't agree with so-and-so or whatever. What is needed is a provision of actions that will resolve disputes. So, but anyway, that's really that's a matter of wordship. What I would like to say is earlier we effectively resolved the question of getting material from the moon and who owns it. There's an associated question to do with an asteroid. If you get hold of an asteroid and use all of the material of that asteroid, then you have effectively claimed it for your use, which is not allowed. So I've suggested, well, I'm not saying this is an answer, but could it be that if you leave some of the material, I mean, even if it's only 1 kilogram, then you have not used all of the asteroid. It therefore still exists in one form or other. And would that be a way around this? It seems a bit weird, but it will comply with the restriction that you cannot claim a celestial body.
Yeah, I think there is another possibility that we discussed in one of our past meetings, that, for instance, the asteroids, let's say under a certain dimension, should be considered dispersed materials and not bodies.
Yeah.
I think this is simpler. Of course, if an asteroid is big enough to be considered already a small moon, or then we can consider a territory. But yeah, smaller rocks can be considered materials. Yeah, I think.
I think Emily has something to say, and then I'll say something on that.
Ah, right. So it's just about the Space Resources Week. If somehow we can skillfully look, the thing is that the treaty, the development of the treaty there at the UN, there's an issue. The developing nations, that Thomas pointed out, the group of 77, they block things because they don't like the capitalism and so on. If the paper that's produced for Space Resources Week now, is somehow, I'm not quite sure how exactly, but not necessarily as a technological argument, but simply an acknowledgement that the resources, lunar resources, are finite, and that the legal framework here needs to be very skillfully developed to be inclusive. I think that would be helpful. Just a suggestion. Silence. I got
No, because we were not sure if you ended
yeah,
your
no,
argument or not.
that was it. I'm just, thinking about, June, if you're developing this paper, I think, the technology, okay, but there's a sort of need in there that somebody needs to say, yeah, we understand. The one that gets there first gets all the lunar ice, and the group of 70 may not want to see this happen. We understand that. Yes. But,
Yeah.
sorry, that was it. Yeah.
Okay.
But this Thomas.
Yeah. Jerry, in answer to your question,
Mhm.
let's go back to the original definition of celestial. You're not able to appropriate a celestial body. A celestial body would be the asteroid in its natural orbit. If you alter the orbit of the asteroid, it's no longer in its natural orbit. It's no longer a celestial body.
Okay, but suppose you mine it.
Now
or
remember, wait,
it
go on. Let me
in
go on.
its original position.
But keep in mind that there is no legal definition of asteroid. Those specks of dust that the Stardust mission just brought back to Earth are no different than Ceres or Vista in terms of the law of an asteroid. It's just those were small enough that you were able to alter the orbit of them.
Yeah.
So, if you're able to change the orbit of the asteroid into a new orbit, then essentially it's no longer a celestial body, and it's become a subject to appropriation by whoever changed the orbit of it.
Yeah, I'm just thinking, suppose you don't change the orbit, you just take the material from the object.
Yeah, if you take the material from it, then what's left is still a celestial body if it's in the original orbit.
Yes.
But then you have to raise the question, will you change the orbit by taking the mass away from it? Because whenever you're taking the mass away from it, you're probably producing a small change in its orbit.
Which leads to other questions. Okay. I mean, there's also the situation that, when we're considering what do you consider a celestial object, because meteors that fall to Earth were originally out in space, and yet once they hit the Earth, they can be owned by whoever finds them.
That's because they're no longer celestial objects.
Indeed.
They become part of the Earth because when they hit the Earth.
Yep.
And that's was part of the definition that people understood of celestial bodies at the time in the 60s.
Okay.
And so then that's why when the laws you have that govern meteorites are perfectly in line with the outer space treaty. And that's also why the Moon Agreement had to include the line in there that specifically excluded meteorites. Because under the original Moon Agreement, meteorites no one could own a meteorite. And that's why they had to include one of the provisions in there was to exclude meteorites from the Moon Agreement.
Yeah, that's okay.
I think we have no international law which is more developed than the Outer Space Treaty so far, and I think we as an international organization have perhaps only to ask questions and to open up the field of possibilities and possible solutions. But I think that we have not to to fix our position now, because we are all not experts in this field, I think.
Of course, we are just making a brainstorming here, by the way.
Yes,
Yeah, because we
it's
are.
a bit dangerous to fix
Yes,
this.
of course, but we don't want to to push those now, just not driving our spacecraft anywhere. By the way, we are missing today. We are missing Wes Fires, who was the principal originator of this discussion, and we are also missing Alfred Anzaldúa, who suggested most of this document that I put in this small reference. And we are also missing Marlène Lausière, that I think she could have her ideas and positions on all of this. So for sure, our discussion here cannot be considered a binding discussion. It's just that we are trying to understand, no, trying to
Okay.
get an orientation in this
Right.
in this matter.
But one thing I wanted to what Jerry was saying, one thing we do need in space law is some way of binding arbitration. Because under the Outer Space Treaty, when the solution to violations of it is the country that feels the treaty is violated has to negotiate with the country that violated the treaty. That's the only dispute settlement in the Outer Space Treaty, is country-to-country negotiations. For instance, when that spacecraft crashed in Canada, which was Cosmos 954, Canada and Russia negotiated how to handle it between themselves. There was no third party they could go to. I mean, in theory, they could go to the UN General Assembly or maybe the International Court, and some have, but that's not really covered in the Outer Space Treaty. The only part of the Outer Space Treaty covers it is that the countries negotiate the solution. That's why private companies under Article 6 are under governments. So that if someone has a problem with what SpaceX is doing, they go to the US government and tell them, and the US government works it out.
Yeah. Okay.
And
So
so what's needed is some kind of international space court or arbitration or something.
now we have just discussed the first point, the point of resources, but I hoped that we could also talk about the orbital debris property,
Did-
salvage, recovery, and so on. But maybe we have to adjourn to another meeting, and possibly.
Yeah, my screen just went blank. Do you still have your screens?
Yes, I'm still sharing the screen.
Okay, because I don't see nothing on my screen all of a sudden.
No?
No, I can see.
The other can see my screen or not?
Yes, yes,
Yes.
Yes.
Everybody's seeing.
Hmm.
Okay, look, it's already an hour and a half since we started. I would agree with Adriano that perhaps we move to this on another date.
Yes, by the way, we will also try to have Wes and Alfred.
Yeah.
But they have important, maybe we can ask the two of them, maybe to Alfred, to hold a small lecture on the concept of salvage, recovery, and reuse of space debris.
That would be.
By the way, we already have a webinar. Yes, I will check and no, I can do it now. We have a webinar made by Alfred on the orbital debris. It was very interesting also from the legal point of view. Let me check.
It could be said that gathering space debris, that is parts of spacecraft that are no longer in use, is similar to maritime salvage. And I know that there can be a lot of discussion on that, but that's something we can look forward to at another time.
Yes, in the NSS position paper, there is also a proposal quite interesting to make a kind of yes, an authority to deal with the big wreckages, the big orbital debris, to rule about the property and all these kind of things, and to make some kind of okay, I'm trying just to remember, so I'm not very accurate. However, to make some kind of bounty.
Yes.
Yeah, Gary. Oh my God. Yeah, bounty context for the giving a prize to the one who recover one of these or other objects, and yeah, to put together something like that, and also other things, of course.
Okay. Just while you're looking for that other piece, Adriano, I'd like to mention that I'm now a member of the National Space Society, and it's a good possibility that I'm going to be one of their space ambassadors, which is really nice. And also, I will be a member of the Space Studies Institute, which was originally founded by Jerry and Tasha O'Neill, and the chair of that is now Roger O'Neill.
Without one single new launch.
I'm sorry.
But in fact,
No,
70,000 new.
I'm sorry, I cannot stop it because I don't know why. Okay, I stop it. Sorry, Jerry.
That's okay. So yes, I'm going to have some new positions to work with, especially regarding space habitats. And meanwhile, as a result of the link I was given to Jan Werner, he has given me an introduction to someone at the European Space Agency, because, as you know, I'm proposing that ESA carries out a feasibility study into the Island Zero concept. So I'm sending him information. Good. Excellent. Yeah.
Okay, so I have put in the chat the link to the lecture made by Alfred on turning orbital trash into treasure. So this is explaining the NSS concepts of turning space debris into a business as soon as possible. That's the way to solve the problem, of course. And yeah, in this lecture, it talks about the liability problem and many other issues and so on. Okay. Yeah. Okay. So maybe in the next meeting we can simply watch this presentation and talk about that, and to see which kind of concept we can consider our concept or not, or maybe introduce them and so on. By the way, in our position paper, I have put a large part of a paper that Alfred and myself presented to the IAC in Baku a few months ago about orbital debris. Therefore, yeah, the main concepts are there and are also in our position paper. Amalie, sorry, I just see.
Oh, yeah. Yeah, just quickly, because it's always difficult to reach you. I think I mentioned I was putting an RFI together to the government about artificial intelligence and the UN, and it's about the 18th SDG as well. Was a physicist asked me to do some work here. Now, what my question is I'm thinking of the next step. So if I send you this thing, it's going to be submitted on Friday, I think, by Lifeboat Foundation. If I send it to you, I'm working with my friend Daryl down the road there, and we would like to write the paper that you had suggested before. And I said I needed somebody to work with. So I just letting you know that I've got Daryl now, and we think we may be ready to go ahead. And I'll send you the RFI. I'll send it to the group so you can have a look and see, you know, how we've brought some of these issues together into focus a bit there. Anyway, that was my update, but I know I didn't want to bother you with a lot of emails, so I thought I'd do it quickly here. Oh, thanks.
Okay. So, well, let me stop sharing. Good. So, well, I think if you agree, we can close here this meeting. I think at least we have took knowledge of many interesting concepts and things, and maybe we will have a way to put them together. But I think that yeah, more or less our orientation toward the methodology of framework agreements for incremental building space law and possible future modification of the Outer Space Treaty and this kind of thing. I think it could be a good choice because it will be based on the lesson learned from the best practices and the systematization of the best practices that will come from the activities. Yeah. Okay, dear friends and colleagues. Okay.
Adriano, I just put a note up saying I have an SRI space law meeting in my diary for Wednesday, February 28th. Wednesdays are now a problem for me. I don't know if you want to have one before that.
Let me check. Let me check. I think it's we are not using Wednesday anymore. I believe, but I'm not sure. So I will now check. Let me check.
I wondered if you just wanted to have a follow-on from this before then. Say sometime in
today I have had the space philosophy meeting that Marie-Luise sent to me. And now let's see, share the screen again. Okay. So, which was the date, Jerry?
I had the 28th of February.
20,
which is
the Academy chairs, the committee.
no.
28th of February.
Okay, so it's been changed. But
let me see.
I won't be able to make that because it's a Wednesday.
February, yes, it's no, it's Tuesday. Ah, no, sorry. No, you're right. It's Wednesday. Yes, it is.
Sorry.
So you don't like Wednesdays?
No, because I'm involved with Frank White's Wednesday meetings, and it's also once a month my astronomical society. And I get the speakers, so I need to.
Yes,
be
yes,
there.
I know that Frank holds a meeting each Wednesday. He invited me too, but I cannot be
Yeah,
a
I know.
Wednesday there.
Too many meetings, Adriano.
Exactly. No, it's not possible. No, by the way, I think there are not so many Wednesdays in our calendars. But yeah, maybe if some Wednesday remain, then okay, we.
But I just wondered though if because we still have this particular area that we mentioned earlier to still be discussed, whether you want to effectively continue this meeting perhaps sometime in January rather than
This
wait.
one of the space law, you mean?
Yes.
Yes, I think we have to because
With Wes and the others who couldn't make it tonight.
okay, we will see what Wes will say because yeah,
Yeah.
okay,
I'll leave that with you then.
good. Well, so
Okay.
let's close now, if nothing else.
Let me there you are.
Yeah.
Merry Christmas, everyone.
Merry Christmas. Thank you very much. Same to
Merry
you.
Christmas.
Bye bye. Ciao.
See you.